Ladies and gentlemen, a very warm welcome to all our participants, dignitaries, and esteemed speakers to the panel discussion on pre-packed insolvency and alternative insolvency resolution framework for MSMEs, organized by the IMC Chamber of Commerce and Industry. Um, all participants will be muted to avoid any disturbances during the course of this session. To consume less bandwidth and have clarity, you're requested to stop video streaming at your end. Kindly post all your relevant queries in the chat section so that the same can be addressed during the Q&A session by the moderator. As we begin our session, may I request Mr. Rajiv Poddar, President, IMC Chamber of Commerce and Industry, to present the welcome address. Over to you, Mr. Poddar.
Thanks, Selvi. Respected Shri Sudhakar Shuklaji, distinguished speakers, guests, ladies and gentlemen, a warm welcome. It's an honor for IMC to have amongst us today Shri Sudhakar Shuklaji, full-time member of Insolvency and Bankruptcy Board of India. IMC is grateful to you, sir, for the discussion this evening on pre-packed insolvency resolution process promulgated into ordinance by the Government of India recently is timely and
President, you are breaking.
Okay, can you hear me?
Yeah, we can hear.
Yeah. IMC and IP Foundation have recently signed a formal understanding to formulate, conceptualize, and arrange IBC clinics, workshops, and training courses with the purpose of providing thorough understanding and knowledge to stakeholders. Sir, we seek your request made to you to grant IBBI accreditation for this purpose of joint courses. Both IP Foundation and IMC have required expertise and infrastructure to run joint courses, and accreditation by IBBI will go resolution process. Pre-packaged insolvency resolution process is yet another important step forward towards ease of doing business after path-breaking IBC code, which was a reform that helped India greatly improve its position in the global index of ease of doing business. Compared to the regular process under the IBC, pre-packed process has the advantage of being a more informal process and the possibility of closure in a shorter period of time. Since the process prior to commencement of formal proceeding is informal, this process gives the stakeholders flexibility in working out with a consensus but efficient strategy for effective resolution and value maximization that may be difficult under the formal insolvency process. The government has rightly deemed it fit to first introduce pre-packs for MSMEs, as they are critical employment to a sizable population. Also, MSMEs in India have relatively suffered most during the current pandemic times, and with the threshold of default debt at 1 crore under the IBC, most of the MSMEs are out of this range. The keynote address by Shri Shuklaji, followed by panel discussions by eminent professionals, will provide understanding, implications, and benefits of the pre-packed insolvency. I would like to specially thank Mr. Snehal Mazumdar and Ms. Sudha Bhushanji for taking this initiative and putting this event together today. Thank you very much to both of you. And conclude a few words about IMC. Established in 1907 and having its headquarters in the heart of the city of Mumbai, the IMC Chamber of Commerce and Industry is an apex chamber of commerce, trade and industry in the western region, and its membership base of over 5 and advocates interest of over 4 lakh businesses and industry establishments across the country from diverse sectors of industry. Once again, I welcome you all to this event. Thank you very much.
Thank you, Mr. Poddar. I now request our esteemed keynote speaker of the day, Mr. Sudhakar Shukla, whole-time member, Research and Regulation Wing, Insolvency and Bankruptcy Board of India, to present his much-awaited address. Over to you, Mr. Shukla.
Thank you, and thank you, Mr. Rajiv, President IMC, and I know Vice President IMC is also present there. So I place on record my gratitude, sense of gratitude for inviting me to be part of this extremely important session on pre-packs to throw a light from the perspective of the regulator. So if you see that the old saying is basically that you cannot withhold an idea whose time has come. So this PPAC was being discussed since the first committee which went into formation of IBC code. I'm referring to BLRC. There also it was discussed, but left it for the future to decide when to roll this out. Now, with the introduction of the pre-packs, PPIRP, virtually sixth amendment has been carried out to the code, and distractors or maybe genuine criticism from some quarters that so many amendments in 5 years reveal that the due diligence process was lacking, and that is why so much patchwork is required in moving forward. But I want to allay that fear that economic law in any setting is incomplete law. And to that context, if you see IBC, even Supreme Court has in the judgment has made it very clear in the Swiss ribbon that this IBC is an empiric law, and it evolves continuously through experimentation. And denial of the right of experiment is fraught with serious consequences to the nation. So to remain relevant with the market, we have to be evolved with the demands of the market and evolving market conditions. So this is how Supreme Court has viewed the changes, because we have not only, we are talking about 6 changes in the statute, but we are also talking about more than 70 changes in the regulation itself. 17 regulations, 70 amendments. It's a lot of, and many of them are happening on the market's call, that this is what is needed in moving forward. On the design aspect of this pre-pack, actually, when we were discussing on the drawing board, we have seen the prevailing pre-pack arrangements across the jurisdictions, and also the best practices emerging from there. So some key lessons were evident from such discourse, and the first one was that design shall not ignore the market solution. So this is the core of this, that if you want to aim at maximization of value, then the market solutions shall not be kept out of the reckoning, whatever principles of the pre-pack you are deciding. And the second aspect which comes out very clearly, that you are saying data in control. So if that is the possibility, then checks and balances have to be intelligently fixed so that this is not put to misuse like by the CD in moving forward to just to delay the process of CIRP. So checks and balances were very important in framing a PPIRP, in moving forward. And the third one was basically you have to balance the interest of all the stakeholders, particularly in the situation when you are compromising the stakes of a particular stakeholder, say OC, and by negotiating a plan which is non-transparent in nature. So you have to see that this non-transparency should not be directed towards the person to divide their stakes in moving forward. So this was very clear that stakes of all stakeholders are to be given equal importance, and to the extent transparency has to be restored in the system, and if transparency is not restored, then the OC's cases are to be handled first, then the financial creditors. Fourth was basically, and this is a part of the report also, which SAU committee said that it has to be rolled out gradually. The SAU committee basically said that it never said it would be confining to MSME. And if you are following the discussion those times, December, January, there was a strong possibility to have a special disposition 240A for MSMEs and pre-pack for non-MSMEs. This was the original thought process. But later it was thought that if both the regimes are more or less same, then why not try pre-packs in the MSME? And why it was tried, I will come to later, because this is very important to park here about the MSME participation at first. Then lastly, it was coming from the BLRC report. They said any process you evolve basically has to be NCLT driven. So, and you cannot keep NCLT out from the process, and it has to be rolled out when markets mature. So these are the two directives which came from the BLRC report. So these 5 sets actually from various jurisdictions and the own BLRC report were very important in framing the this PPIRP. And now if you read, you will see that all 5 actually concerns or whatever other jurisdictions have tried to roll down have been adequately addressed in this framework. Then we see the development actually. SAU subcommittee was of ILC was set up in June, and the report was submitted 2020. This is at the time of first wave of COVID, and the public comments were invited in January 2021, and public comments were deliberated extensively in February and later March to bring this PPIRP into shape. So this is extensive comments from the public were taken on board to see that it has a wider consultation and the reflection of the demand of the market. So we again care very much what market players are saying, and that's what we did in the consultation process, and the PPIRP was rolled out. And the timing actually has been also very critical. When to roll out was the issue. Then if you see, 2 things happened in the last week of March. First was 7, 9, 10, which were suspended, were restored with effect from 25th of March 2021. And also simultaneously, the stay on standstill clause of RBI was vacated by a Supreme Court. So now these 2 events triggered that there should be, and a question was whether with the opening of the market, market would be flooded with the demands for solutions under IBC or not, and if yes, whether SMEs are to be treated differently than others. And again, what about COVID default? What if COVID default has happened and you don't take cognizance of that? How you will cure that? Basically, that was also under debate after opening of the market. So to these two questions, whether what happens to COVID default and whether MSME or not, both questions were answered in affirmative. Actually, it was decided it has to be a system to begin with only for MSMEs, available for MSMEs, and the default actually COVID-related default by the ordinance itself says the limit is to be decided by the government, and government has notified on 9th July the limit being 10 lakhs. So any default happened between 10 lakhs and above can be drawn into PPIRP process. So 10 lakh to 1 crore is the one which is a COVID related default, and the 10 lakh below still is in hanging, in the sense it has to be dispensed with the other instruments available with the creditors. So this is about the timing. Then we say the MSME, why? Because study after study was indicating that pandemic is, and this is the IMF's recent March report, that pandemic is affecting SMEs disproportionately. So this is a conclusive reports coming from the international players and also emerging evidence from India that MSME have been affected the most disproportionately, and they have to be addressed. And even the budget 2021 actually mentioned that MSME special dispensation is to be announced, and we have to see that this is rolled out within this financial year. So mandate came from the budget speech itself, which said that alternate method of resolution for SME would be rolled out. So this can be seen as a part of the budget announcement as well. So ordinance, everybody knows, came on 4th. We were ready with the regulations. Timelines were very tight to us, but we came out with the regulations on 9th. Rules were notified on 9th. So whole institutional infrastructure, or you say legal infrastructure to roll out the PPIRP was ready by 9th. So now we are waiting how the cases are being filed, and to my information, till date, no case has been filed under PPIRP, and it was expected so, because there is a certain time which is required to be devoted by the CD in preparation of the base resolution plan. So this is very important, because base resolution plan is coming from CD. He is preparing an interim resolution plan, resolution memorandum, and also all the information related to avoidance transaction, and also about the creditors is coming from the CD itself. So CD is at the helm. CD is initiating. CD is preparing the base plan, information memorandum, and the claims register. So this was a game changer, in the sense now CD has vast power to initiate. If he does not initiate, it will not be like anybody does not have authority. Any financial creditor or OC has authority to roll out a PPIRP without the consent of CD. So CD has to do it, and CD has to initiate it. If they don't want, like other financial creditors, and do have authority and do have option to go for alternate courses under CRP or like. So this is how we have protected the CD's role in this PPIRP. Then we have tried to I have very limited time, but I will just say that if you see the objectives of the code, because in the newspaper we are saying that we have violated the objective of the codes by announcing the PPRP. So I just wanted to harp on the question that what are the objectives of the code? One is reorganization and is insolvency resolution. Definitely, Swiss Bank or you say ArcelorMittal case, everywhere it is saying that code is like liquidation is not mentioned in the primary as a primary objective. So they are striving for resolution, and this mechanism is only for resolution. It is what we say is a liquidation remote. A very remote possibility of liquidation is allowed in the case of some fraudulent activity is discovered. Otherwise, you cannot force a company to liquidation under this dispensation. So this is what, in line with the reorganization and insolvency resolution, from going concern perspective also, like it has to be, company has to be going concern, it cannot be liquidated. So employment preservation is at the top. Maximization of value, again, COC has the right to call for alternate base plans, alternate plans which will compete with the base plan. And this, we don't call it a Swiss challenge, but it is a variant of it. Basically, if somebody in the market is presenting a better offer, which is significantly better than the base plan submitted by CD, then that would be considered by the COC. Otherwise, if it is not significantly better, then there would be competition between the alternate plan and the plan submitted by CD to bid off by a margin of tick. So this is basically, we are saying that if say, and this is again COC is deciding whether it is tick size is X% or not. Whatever the decision of the COC on the commercial side they take is final now in this regard. So this is what I wanted to say. I have many more things to say, but I think time given to me is this much. I will end here. We say this is a fusion. And philosophy is very clear that at informal stage, no or minimum intervention, and in the post initiation, there is a quite a vigilant dispensation to ensure that this process succeeds. I think I will end with these words. Thank you very much.
Thank you, Shukla sir. Mr. Sahu could not make it as he is unwell, and Mr. Shukla came in for him at a very short notice, and we are highly grateful to him for the same. Thank you, Mr. Shukla, and thank you for that wonderful insight given by you. I now hand it over to Mr. Snehal Kamdar, CA, IP Managing Trustee, IP Foundation, to present on pre-packed insolvency, followed by the panel discussion. Over to you, Mr. Kamdar.
Thank you, Shelby. Thank you, Shukla ji, for your keynote address and giving the insight to everyone on the how BLRC played a role in the formulation of this pre-pack, and how the pre-packs are visualized by the regulator and the lawmakers. So now onwards, basically what we are going to do is I will be sharing the screen. I will be taking you through a small presentation before the start of the panel discussion, and thereafter the panelists will be there. My presentation will cover a part of why pre-pack, benefits under pre-pack, and all, and the detailed pre-pack discussion will be taken through the eminent panelists, followed by a Q&A of 15 minutes at the end of the session. Just a minute. Yes. So welcome all for this prepack insolvency resolution process panel discussion. Before that, this PPT will take you through the what is all prepack means. So prepack insolvency resolution process. What does it mean? It is a new option for a resolution of stress under the code in furtherance of its objective. So a MSME which are in stress, option for them is given under the code, whereby they can relieve themselves of the stress, they can restructure themselves and come out again and run the show. A prepack has emerged as an innovative corporate rescue method that incorporates the virtue of both informal out of court and formal judicial insolvency proceeding. So as Sudhakarji is in his keynote speech said that the prepacks through NCLT was what was being discussed, and over a period can be informalized. So in the initial stage, it's a innovative corporate rescue method where the corporates will come with an informal model and get it formalized through a judicial proceedings. So it seems to be a preferred hybrid framework as it empowers stakeholders to resolve the stress of CD as a going concern. So what is prepack? Prepack is nothing but a restructuring plan which is pre-agreed between corporate debtor and the creditor. What does it mean? So under the prepack, the corporate debtor, like what we do in CRP section 10, where the sumoto it goes and the CD files. Here in prepack, the initial work is done by the CD. He prepares the base resolution plan, and that base resolution plan will be put to vote by the in the COC, and based on that, the outcome will become. So it is a restructuring plan which is pre-agreed between the corporate debtor and a creditor prior to insolvency filing with the court. So when in insolvency in the CRP, as we used to do, what used to happen was we used to file an application. Initially, the RP used to take over the operations of the company, and thereafter the process used to be run by the RP. Here, the process will be under the control of the CD. Prior to the reaching the court, he will have to do the base work. Thereafter, the court will give it the sanction to enter the prepack initiation, and thereafter RP will supervise. But the operation will always remain in the control of the CD unless and until the situation mentioned in the ordinance, which will be discussed in the later part of the event, happens, and whereby the RP vests with the management of the CD and takes over the process. So this process, the final sanction by the court in a time-bound manner. This prepack is being visualized. Like in India, the MSME is a major part of the industry. So when you consider the major part of the industry and in this turmoil situation of this pandemic, whereby as again our keynote speaker drew our attention on the points that the IMF in its March also said that the MSME are the one who are hit by this pandemic in a very disproportionate manner. The opportunity for them under prepack is to revive the organization, come out with a solution, and run the show in future, which is the object of the insolvency. And once, because the prepack gets the sanction of the adjudicating authority, the NCLT, it's similarly, it is like CRP resolution plan binding on all. Here also the plans are binding on all. Why prepack? The prepacks are being discussed. Why prepack? The default limit during last March was increased from 1 lakh to 1 crore, and the talks were now, because of this 1 crore limit, lot of MSMEs will have a issue. So in that scenario, the options for the MSMEs were not available. So this 1 crore limit, which was there was no policy for defaults lower than 1 crore. Now with the default, smaller default of 10 lakhs and above, basically the prepacks can be a way of resolving the issues. So why prepacks? Smaller default required different treatment. Prepack less time to be consuming compared to CRP. MSME in CRP ended mostly in liquidation in most cases. And to cut time and resolve issue in MSME, the prepacks were designed. So what do you, the prepacks, the formation of prepacks, the discussion which was being taken since the initial days of BLRC, how it will be impacted with this prepack coming in, the default being reduced to 10 lakhs, so 10 lakhs to 1 crore, even the COVID default would be covered in that, and the benefit of this can be taken by the MSME CDs, and they can work on the prepacks. Default limit to initiate PPRP. As I said, the first point here is the default is to be a must for the prepack. So like section 10 or basically here also a default requirement is that unless there is a default, the prepack cannot be initiated. A default is a must for a prepack. It should be not less than 10 lakhs and there is no upper cap to it. Benefits of the prepack: it's an informal process, a minimum disruption to a debtor's business activity, shorter time for the closure, increase the possibility of resolution, lower direct cost, minimize indirect cost in terms of stigma and loss of reputation of the business, and fixes responsibility for payment of RP fees. So here in prepacks, RP fees, who will pay has been clearly mentioned. So RPs who have to go in CRP to the NCLT for their fees. Now here it is predefined who will be paying the fees, and the forms also which are needs to be filed has to mention the clarity, the fee structure. So this will help the RPs also in running the prepacks. It's a completely informal process in the initial stage, whereby till the initiation starts or till the order comes of the prepack initiation by NCLT, the lot of groundwork has to be done at the CD level, which we'll be discussing in the panel. I'll not go into that detail at this point of time. Early initiation and closure of process minimize the possibility of liquidation, ensures a company keeps going, and lower the burden on court and lower the litigation cost. So this is what the benefits have been enumerated. Now to this benefits, what the cost factor which has been mentioned, that it will be lower. We will come to see how the cost will be lowered over a period down the line, whether the CRP cost what was there and in prepack what is the cost that will be incurred, whether the cost will be reduced or not, that also over a period only the time will say, and we'll come to know on this part. The important timelines that is there, which we need to take care of in the prepack, like on the start of the prepack initiation date, we assume it is T+0. So on the date, it's a date of pronouncement by the adjudicating authority of the prepack being initiated against the CD. based on the application filed by the CD with the name of the RP, consent of the RP attached with it, and the 10% of the unrelated FC having approved the name of the RP whose name is suggested in the application. So here there is a timelines that has been defined. T+2 public announcement has to be made, and the same day the CD has to submit the to the resolution professional the claim list, the base resolution plan, and the preliminary IM. So here in the public announcement, the difference between the CRP and the pre-pack is that there will be no public announcement through newspapers. It will be through the website of the CDs and the regulators. The appointment of the valuers to be done on T+3 days. On T+7 day, a constitution of COC has to be done, and first COC has to be done by 14th day. And in that COC, the RP has to hand over the IM to the COC. By 21st day, a public invitation to resolution plan has to be made, and by 38th day, opinion to be formed on the avoidance transaction by the RP. The timelines to do this avoidance transactions forming opinion 30 days is something that will have to be looked into by all the RPs who start working on the pre-packs. By 45th day, the determination of avoidance transaction has to be done, and by 68th day, the application has to be filed with the adjudicating authority on avoidance transaction. So a tight timeline on avoidance transaction is given. Here, by 68th day, application needs to be filed on the avoidance transaction. The question on this, we will deal in the panel how this can have an effect on the pre-packs also. On 98th day, by 98th day, the COC has to approve the resolution plan, and by 128th day, the approval or the rejection of the resolution plan has to happen by the adjudicating authority. So to sum up, in short, the pre-pack timelines gives you an indication how fast and the company which is in trouble through pre-pack would be able to resolve. And if these timelines are met in the realistic manner, like what in CRP we have seen that the timelines which is given how we are in the initial days had exceeded numbers what was given, and then gradually and slowly the control on the timelines has been maintained as of now. But it is always a challenge to have this strict timelines to be matched. But in view of the code and the in situation that the MSME is, if these strict guidelines are followed and are applied, then in my view, the things will, the pre-pack can go in a big way. So with this short brief about the pre-pack, because detailed discussion, we will take it through our panelists, eminent panelists will take their views on this, and we take it through them. So thank you for going through being with me on these pre-packs, and we take it ahead on the panel with the panel discussion with our panelists. Thank you all. And to start, before we start with the panel discussion, I would take a privilege to introduce each of my panelists who would be there with us to guide us through this pre-pack. Our first panelist will Madam Sudha Bhushan. So Sudha Madam is a chartered accountant, a company secretary, and an insolvency resolution professional, and also a registered valuer and an independent women director registered with MCA. She is a co-founder of a Texpert Professional, a multifaceted consulting company, and she is an advisor to Bank of Baroda, NRI and international operation. and empaneled with HDFC Bank. She is presently an independent director in Choice International, Orion Pro Solutions Limited, FinQuest Financial Solution, Digjam Limited, Matix Fertilizers and Chemical Limited. FinQuest is a well-known NBFC which has been a resolution applicant in a lot of the companies, and Digjam is a listed company which has just come out of CRP process. She is an advisor to a lot of multinationals company, including Fortune 50. She has more than 2 decades of experience in audit, international transaction advisory, business structuring, and regulatory affairs and valuations. She is a co-chairperson of Business Environment Committee of IMC Ladies Wing. She is a member of Indo-French Chamber of Commerce and Industry, and she had been a member of Committee of International Taxation of WRC. She has also been throughout her life, she has been awarded with many awards, including Women's Empowerment through CA Profession by NIRC of CA Institute. She is a noted speaker and has addressed various national and international forums. Like Horace is Asia Meet, her articles are regularly published in journals. With this brief introduction of Sudhaji, I introduce the others, panelists, Mr. Ashit Shah. Ashit is an equity partner and chairs the finance practice in J. Sagar Associate. He has been with J. Sagar for more than 15 years and is regularly advises on Indian and multinational banks, credit funds, and Indian borrowers in a complex and structured credit facilities, as well as on restructuring such facilities. He is actively involved in advising various stakeholders through intricacies of corporate insolvency resolution process under Insolvency and Bankruptcy Code 2016. He has been involved in insolvency and debt restructuring of various companies, including SR, Bhushan Steel, Chuchi Soya, Eco India, Usdev, Meenakshi Energy, Altico Capital, and Shapurji Panelji. Ashit has been recognized as a leading lawyer in the banking and finance and insolvency practice by several international publication and organization, including IFLR, Legal Fire and Trade, Chamber and Partners, and Asia Law. And he has received a Banking and Finance Lawyer of the Year 2020 award for India by IFLR 1000. Other panelists, our Sri Sanjeev Pandey. Sri Sanjeev Pandey is a head of NCLT division at a stress asset resolution group of State Bank of India. Mr. Pandey has started his career as a professional in 1986, and during his 34 years has worked at different assignments and different levels in SBI. He has handled restructuring of distressed loan under BFR, CDR, and other schemes. He has also carries international banking exposure, as he had been posted head of treasuries and investment as SBI Singapore in 2009 to 2014. Mr. Pandey, while in deputation onto IBBI, was associated with drafting of IBBI regulation on CRP, voluntary and compulsory liquidation process. Mr. Pandey has organized number of training workshops at IBBI for training the newly registered insolvency professional. Currently, he is head of the NCLT division of SBI and is responsible for initiation and monitoring more than 900 cases of CRP and liquidation. Mr. Pandey has authored the official training of resolution stress asset of SBI for the officers involved in management of the stress asset. And our esteemed another panelist, Mr. Dushyant Dave. Mr. Dushyant Dave is a practicing cost accountant and insolvency professional. He has handled a dozen of insolvency assignments from 100 crores to 30,000 crores. He is a founding director and a chairman of IBBI registered IPE Decode Resolvency International Private Limited. He advises domestic and global investor for the investment into stress asset, and he is a turnaround and restructuring expert with a corporate advisory service of 25 years. With this introduction of our esteemed panelists, I would like the panel to give each of the panelists can share their views for 2 or 3 minutes on pre-pack before we start on the Q&A part of the session. Yes, Sudha madam.
Thank you, Snehal ji, first of all, for such a wonderful introduction and wonderful event organized by IMC. I would like to congratulate Rajiv ji for taking this initiative, for organizing this event for the benefit of MSMEs. And thank you to Sudhakar Shukla ji for taking out time at such a short notice. And also, I'm happy to be here along with Sanjeev ji, Ashit ji, and Dushyant ji and yourself. If you regarding my comments on this pre-packaged insolvency process, now if you ask me, Snehal ji, I think after the digitization of MCA, which we had witnessed in 2003, the induction of IBC and now this prepackaged insolvency, which I'll be calling PIRP, is one of the most impactful reforms that I have witnessed in my professional career. It is proactive, incentive, compliant, market-led, and time-bound. In fact, we all know that after implementation of IBC, India's rank, as pointed out by Rajiv ji and Sudhakar ji as well, that India's rank moved from 136 to 52 in terms of resolving insolvency in the past 3 years in the World Bank groups doing business reports. And in the Global Innovation Index, India's rank improved from 111 in 2017 to 47 in 2020 in ease of resolving insolvency. And we all know that it's easier to resolve stress in the economy. It would encourage companies, domestic as well as overseas, to do business in the country. Now, in general, if you see, there can be two types of stress in the companies. One may be the market-driven, and one which may arise due to the incompetency of the management. Now, if such a stress is not taken care of, if such a stress is not given the opportunity to be corrected, in that case, closure of it will happen in lot of closure of the otherwise viable units. Now, such a closure of such viable businesses is not in the interest of the stakeholders, be it any stakeholder, be it a shareholder, your creditor, your employees, your suppliers, customers, anyone in the economy. So it is necessary, it had been necessary to facilitate the stakeholder to resolve such a stress. In fact, IBC, if you see, it has changed the whole of the game. So the defaulters paradise that used to exist before IBC is lost now. So many debtors, and it is absolutely it can be it's based on the statistics. Now, let me share some statistics with you that there are more than 14,500 withdrawal of application at pre-admission stage that has happened. There are closure of more than 200 CDs under Section 12A of the Code, termination of CIRP by adjudicating authority, closure of CIRP on taking note of settlement, recorded by the mediator, and even the settlements at the level of apex court where the parties worked out at the resolution, amicably resulting in the swift revival of the CD. So if we can see that a fair debtor and creditor relationship induced by the court had already promoted several resolutions in its shadow and in its account. And however, at the onset of COVID-19, when we saw that there are several companies, big and small, that are coming for the filing of bankruptcies. In fact, as one of the report that says that 64% of the businesses across all industries in UK were at the risk of insolvency in September 2020. And globally also, corporate insolvency are forecasted to increase by 26% in 2020. Now, there are so many options that are given to
Madam, I will take you on this statistics in the questions that I have for you, because the idea what I want is each panelist of us should give this remark basically on so that on which I will be formulating question. So from the points that you have given me, I have my ready questions for you, which I will be taking as the things come. And
Still one thing that
yeah.
I want to make here, that because of the COVID time, where do you find the RA?
Yeah.
So this pre-packaged
So
that's
this is
what,
all things all the participants will like to hear from all of you, that how these things pre-packs can be made a successful event, and what are the key ingredients. That's why we kept it open in my presentation. Also, I have not went into the detailed analysis of it, so that the eminent views of your are taken into consideration. Yes, Ashit, can you just have a quick 2 minutes on pre-pack? What are your views? So that accordingly, I also take care of my questions to you in the coming discussion.
Sure. Thanks, Nehal. And first, I'd like to thank the IP Foundation and IMC for giving me the opportunity to be here. It's a very topical issue, especially given that the IBC proceedings, the suspension period has now been lifted. The MSMEs, which constitute a large chunk of companies in India, provide large number of employment opportunities, have really suffered tremendously in the pandemic. And therefore, introducing the ordinance at this time is really opportune. I think there are a couple of, Mr. Shukla and Mrs. Bhushan have already spoken about this. You have also touched upon it. There are a lot of benefits about the pre-pack ordinance, given that it is a debtor in possession model and therefore will continue to enable preservation of value of the assets. In addition, there are checks and balances because there are some controls which are with the creditors, including the issues under Section 28 of the IBC, where creditors' consent will be needed. A few important points about the pre-pack compared to the other restructuring processes. One of the most important points about the pre-pack is that it allows for a moratorium. And I compare this to the June 7th framework, which is currently available, which is an out-of-court restructuring process, where the moratorium was not available, and that resulted in various challenges. So this is one of the advantages, I think, of the pre-pack system. The second one is that the June 7th framework, if I compare the pre-pack ordinance to that, it does not allow foreign lenders, foreign investors, funds to participate. It's only between the Indian banks and financial institutions. So the pre-pack process really involves foreign financial investors as well in the whole process. And given that it is going to go through the blessing of the NCLT, it gives the entire pre-pack process legal sanctity, as well as the fact that it will be binding on all stakeholders. So I think, therefore, a pre-pack from an MSME perspective is definitely more preferable than any out-of-court restructuring process that we have so far. There are checks and balances which are already in place. At the same time, I think there are certain provisions of the pre-pack which are quite ambitious, such as the 120-day timeline and processes around getting the PUFE transactions completed within a certain time frame. So we can discuss some of those issues going forward, but I definitely think it's a step in the right direction. And as Shuklaji said, I think its time had really come.
Thank you, Ashit. Thank you. I invite Dushan Bhai to share his view. Dushan Bhai.
Good afternoon, everybody, and thank you for inviting me to this esteemed panel on very topical point, which is pre-packs. Pre-packs is going to be a game changer, in my opinion, in the insolvency entire resolution process of any stressed company. Being associated in the large CRP for since the inception of the act, we always found that it would have been perhaps better if the promoters and banks had sat down together before taking the company to the insolvency. And this is what now is happening in the pre-pack. And this is how the whole pre-pack word is something which we're toying with since last couple of years in various forums. And we were inviting people from UK, Australia and Singapore to talk about UK. I've taken part in a couple of such discussions. And you're wondering how we will introduce the pre-pack. So as Mr. Shukla rightly said, the time had to come. And this has come during COVID times. MSME, as you know, so this whole pre-pack ordinance, I think if you look at the preamble of the Act ordinance, it says it all. It says in the COVID times, there are so many distress and, how do we take care of them? And MSME, which is the backbone of any economy, not only Indian economy, I think we are approximately 24 million MSME across the country. How do we have the same CRP process applied to MSME? We found it won't work. MSMEs are located across India, across towns, small companies, single banker, facilities from 10 crore, 50 crore, 5 crores. How do we do that? I think this process, which is keeping all of a sudden, now we are going to learn debtor in possession. We learned how the creditor comes to control and IT controls the companies. Now we are going to have a debtor in possession. That's how we are going to now witness it. And how honestly the people come out. In my opinion, though there are apprehension, but MSMEs, if they are already into a stress because of the COVID situation, and if they come across very, very candidly, and they take advantage of this pre-pack regulations, which of course details we are going to discuss, the problems we'll also discuss in the panel. It is going to be really helping them, because in India, there is a culture not to talk about your distress. You find out, you raise the fund from friends, relatives, and keep on struggling. But why? In a company, as much as you are successful in a business, you are also having a right to fail in a business. And that's where the whole system is going to take care of. I am quite optimistic about this, and I'm sure this pre-pack is going to be a game changer for the entire MSME sector, and later on when it graduates into the larger companies as well. Thank you.
Thank you, Dushyant Bhai. Sanjeev sir, over to you. I think we are again, me and Sanjeev sir again had been a part of another panel in the just 1 week's time. Again, we are here together, and it's always loved to hear you on this topic of IBC. So, sir, your views on pre-pack before we start a discussion. This is basically to gauge what questions I need to push across to each of you as a speaker, sir. Thank you.
Thank you, Snellji, and thank you, IMC, for having me here. So, I think good opportunity to share our opinions. Since I have been engaged with this law since beginning, I was part of IBBI, I think from the second day of its functioning. So we have been through drafting of regulations, like thrashing the code line by line to understand what lies behind and everything. So initially what we understood that it was a non-adversarial law. When it started, so anybody CD or OC or FC, anybody can take it to NCLT with a small amount of default. Gradually down the line, it became adversarial somewhere. So as we all know, 29A made it a kind of adversarial law. And that defeated some of the basic fundamentals of IBC. And the result was that many of the companies started going into liquidation. I know when this provision came, so since we have to provide our opinion whenever something big changes, so generally that is the position of State Bank, that we have to provide our opinion. So government takes a feedback from us at least. So we vehemently oppose this, because we said that this SMEs will be killed because of this 29A. You can find buyers for SR Steel, Bhushan Steel, large ones, but smaller businesses hardly find any buyers. They are only promoter driven. And if you remove the promoter from the scene, nothing else but liquidation is the solution. So then 240A came, so they took our advice, and then it was good. But ultimately, still we see a lot of litigation going around in IBC, and 80% of the cases landing in liquidation. So that is where I'm coming from. This pre-pack makes it again a conciliatory kind of consensual mechanism, where we start with the promoter. And I have studied the data and the insolvency regimes of at least 5 or 6 countries, including US, UK, Singapore, Australia. So we have seen that most of the resolution anywhere in the world, they come from promoters. So that is a fundamental of IBC or insolvency law, any regime, because he is the father and mother of this unit CD. If you remove the father, the parents, and you want to bring up this child who is in trouble, who is a sick child, it is very, very difficult. You take it from me. So that is fundamental to this pre-pack, that we are talking to the parent first. We are talking to the mother and father. You tell us where lies the problem. There we start resolution. Then of course the attendant incentives are like lower cost, because the CD or the RP doesn't have to take care of the unit, the CD operation of the unit. That's a big change. Then the process is quick, 90 days. Best thing is that I expect much less litigation here, because the promoter is filing and the bank is giving their consent, FCs are giving consent, to who will protest. So I don't think much litigation will happen at the initiation stage. We are having more than 100 cases of CIRP pending in courts more than 1 year, just for admission. So I feel that this should happen not in 14 days, maybe 30 days. Then the biggest advantage of having a resolution, whether with the promoter or out of the promoter with somebody else, is having a NCLT stamp on the resolution plan. So this brings the benefits of all out of court resolution at the same time in court process. So this is a good combination of both informal and formal, out of court and in the court process. So I feel that this is a very good start, and I hope that this will be also provided to bigger companies, because MSMEs, yeah, they require this, but I think it should not be restricted to only MSMEs. It should be available to all the corporates, wherever the promoters are, I think, competent enough and qualified enough, eligible enough to go through the process. That's all. Thank you.
Thank you, Sanjeev ji, for your inputs. Now to our panel. As always, ladies first. To Sudha madam, my first question from what you said goes to you. Basically, you have been dealing, what I understood from your profile and things, that you have been dealing with regulation internationally. So how is the pre-pack insolvency law all over the world, and how successful you think the things will be in India, and what will be the expectancy of success of this in India? If you can throw a light on it.
So as such, the pre-pack insolvency law, if you see, it's a law in formation globally as well. So as Sudhakar ji has said, that any economic law is essentially empiric, and it involves continuously through experimentation. To stay experimentation in things economy is a grave responsibility, and the denial of right to experiment is fraught with serious consequences to the nation. So this code is also no exception, and has been for globally, it has been a road under the construction. Now, pre-pack, if you see, has different nomenclature, such as pre-packed insolvency resolution, pre-arranged insolvency resolution, and is known with different names in different jurisdictions, like pre-planned sale in US, pre-pack sale in UK, scheme of arrangement in Singapore. Now, it appears that pre-pack as such has no statutory definition. It is probably also because it has evolved over a period of time in different jurisdictions, and then these different jurisdictions have adopted this act in a different manner as it has suited to their different economies and in different unique variants that it had. Like in UK, we have this, it didn't come as an act, and it evolved over a period of time and through the market and professionals innovation. However, it got the code which supported the evolution. And in US also, the US bankruptcy code facilitates three forms of pre-packed, namely the pre-packed plans, and then you have a chapter 11, and then packaged bankruptcy proceedings. Now, as far as its success in various jurisdictions is concerned, if you see, the pre-pack sale in UK could be completed in a matter of hours from the appointment of administrator. As preparatory takes place, all the preparation takes place before the appointment only. And the average time that is taken by the court to confirm the pre-packaged reorganization plan in US is around 2 months, also, one of the objective of this prepackaged insolvency is also to keep the employment intact. Why otherwise the control will be given to the corporate debtor, because it was also ending up into the lot of unemployment. And as far as if we see that the countries which has adopted the prepack insolvency, like in Netherlands, they were able to retain the job previous to the prepack adoption. It was 34.6%, and after that it was 54.1%. So given the very nature of the law, which is trying to blend in the benefits of informal way and the formal way, and looking into its success all over the jurisdiction, I think it should be very successful in India as well. However, there are a few things that we need to see. Is one thing definitely is to increase the infrastructure of the NCLT and complying with the deadlines, complying with the timelines. So if we can see
Yes.
that you have to,
Uh,
yes.
From your timeline point, I would like to take it to Ashit. That Ashit, in CRP, you have been continuously following various cases, high-profile cases, as we understood from your profile also when I read it. So, how do you find the timelines in the pre-pack, and how practically it can be adhered to? Do you have any suggestion on timelines?
Thanks, Nihal. Well, I think the timelines, as the IBC experience has shown us, have been very ambitious. In the IBC also, we had 180 plus 90, 270-day timeline, which got extended to 330. The average IBC cases are taking longer than that. And the courts have, in their wisdom, also held that a lot of these timelines are not mandatory, but directory. To the extent there are exceptional circumstances, you can extend those timelines. I think that as far as the pre-pack 120-day timeline is concerned, it can work, and I'll tell you why. Because the pre-pack process is split up into two stages. You have the informal stage, where you are actually agreeing on a plan between the company and the lenders. And once you have a plan agreed, an application is filed with the NCLT to admit the pre-pack process. So therefore, there is already a lot of groundwork which gets done before the plan is admitted into NCLT. You have a base resolution plan which is already in place. You have the list of creditors already in place. There are, I think, a couple of things which maybe can be considered to make this even more effective. For instance, the regulations currently provide that the valuation of fair value and liquidation value will be done by the RP after he is appointed by the NCLT. Now, this seems, a bit strange, because whenever the financial creditors are going to approve a base resolution plan, and the base resolution plan has to be approved effectively by them before the corporate debtor makes an application. Now, when the financial creditors want to approve the base plan, they will want to know what is the liquidation value and the fair value. They're not going to wait till the time the plan gets the application gets admitted by NCLT. So if we can prepone that process and have the liquidation value and fair valuation done at the outset during the informal stage, it will help in saving time. Otherwise, valuation processes take ages to complete, as you know. The second thing is that the corporate debtor has to make a declaration of any preferential, undervalued, fraudulent, or extortionate transactions, right? Either that there are none, or if there are any, they have to put that out there on a piece of paper and submit it. Now, once the RP comes in, as you mentioned in your timeline chart, within 30 days, he has to take an opinion on whether the preferential, these PUFE transactions or avoidance transactions are actually existing or not. For an RP to do that, again, we know from our experience in the CRP process, it takes a lot of time. Even when the RP is in the management of the corporate debtor, it takes him a lot of time to unearth all of these processes. So one of the things that again can be considered is that since there is a declaration that the directors have to give about these avoidance transactions, prior to the declaration being given, there should be a mandatory forensic audit which is conducted in the informal stage itself. And that mandatory forensic audit which is conducted, right, it can be conducted by a person appointed by the financial creditors, because anyways you need 66% of the financial creditors to approve before an application can be made to NCLT. So again, if we can prepone the forensic audit time period in the informal stage itself, you will again save a lot of time, because that informal audit will be able to, sorry, that audit in the informal process will be able to actually verify the declaration which is being made by the directors. So the RP's job becomes easier. So once you have that, then effectively the base resolution plan you have is a very strong plan, because creditors have already approved that plan. Now, one of the other challenges I see there, Snehal, is that for the base resolution plan should not impair the value of the operational creditors. And if it does impair the value, then you will have to go through a Swiss challenge process effectively, where you will have to invite creditors. That is where I see some sort of protraction of the timelines, because 2 months or 2.5 months is insufficient to complete a due diligence and negotiate plans. So I think if the base plan itself is strong enough and it goes through all of these checks and balances, the intention of the the pre-pack process will be really met, and you will be able to complete this process within 120 days. Otherwise, it will really take longer. That's my view on the topic.
Yes, taking cue from you, Ashish. Ashit, over to Sanjeev sir, because this forensic point and all had been the talk where Sanjeev sir had been also giving the same view in the past. So my question, little bit different here, sir, to you is how far the banks are equipped to handle this pre-pack timelines. We RPs always find it very easy to adjust to all timelines from 180 days to 270 to 330, and now again from 120 days it has come down. So all these timelines, as Ashit said, that a judiciary member, judicial has been regulatory saying that it is directory in nature, but to us it is we take it in our stride as a mandatory in nature, and we try to achieve all the timeline given to us. So here, but we find it always a challenge with other stakeholders in the meeting the timeline. So question from to you is how far the banks are equipped to handle this pre-pack and the timelines given in the pre-pack for the COCs.
Thank you. Yeah, I totally agree with Ashish bhai that we need some kind of like informal part of the process should be used like maximum to the maximum. That is the time available in ample to all of us, whereas the time in the formal process is restricted. So the more effort you make during the informal part of the process, you have a successful plan. So as far as the preparation goes, I can only talk about SBI. And we know that whatever we do, it is copied everywhere. So I'm comfortable with that. So we have already, like, banks work on the circulars, you know that. Especially, I can talk about public sector banks. Unless we come out with a detailed circular, nothing will move in the branch. So whatever you do, anybody can go with a plan or whatever. So we are ready with our policies. I'm working on the SOP. By the time policy is approved by the board, so SOP will be there. So these are two major documents on which the branch function. We try to make it as elaborate and as like user friendly to make the process very clean and efficient. So that is my role as a sitting at headquarters, to provide them tools for this process. Then comes the training part. So we have already held training for like 2 levels of my officials who are dealing like DGMs and one with my GMs all across my LHOs. So there also we have kind of sensitized them about the changes in the law. Although for them even IBC is a new law, because IBC was mostly handled by my department and my vertical. So now this affects all my entire bank, because this is not only the NPAs, this is only affecting the default accounts like SMA accounts or the account which may be going into default. So my sense is that we will have to be proactive to the extent that if a borrower approaches us that, sir, I may not be able to pay the interest for this month or the next month. So should I go for this? So we should start from that stage. We should not wait for a default to occur first. So that is the kind of proactivity required here, so that we can plan the default. Because ultimately every bank is concerned about a generation of NPAs. We all know that. Our concern is that whatever we do, but it should not be NPA. So if we can plan a base plan in the manner that it goes as a perfect plan to COC, it is approved within 20 days. We don't have to go for all that Swiss challenge and all. And then we get an approval. So within 90-day time from default, if we have an approved plan in hand from NCLT, I think that will be an ideal situation. But to reach there, so we are kind of also, as you mentioned, so I am suggesting that it is safe for both the borrower as well as the lender to go for a forensic audit upfront, and also engage a RP upfront. So even before giving approval to RP, you engage the RP from at least 3-4 months before the application is filed, so that this RP will assist the borrower in preparing the plan, in preparing the IM. So he is thoroughly into the process and totally aware of the goings on, and doesn't enter the process at the last stage. That is my. Thank you.
So taking cue from you, so over to Dushyant Bhai. Dushyant Bhai, you have handled large accounts in CRP, and now this MSME accounts, when you are looking, what has been understood in most of the MSME account, they lack a lot of financial discipline in their things. So as an IP, what are your comments on delivering your obligation as a IP or RP in the given timelines? Are timelines sufficient or less? And vis-a-vis your thought on the base plan, as base plan is the heart of this pre-pack. If the base plan is to be understood with respect to there is a differentiator between what we do by way of evaluation metrics, looking at a resolution plan. And in this pre-pack, we take a base plan. And in case of there is a significantly variant other plan is coming, then with respect to tick size, how do we evaluate? If you can throw a light on this, it will help everyone to understand the process on this.
Yeah, thank you, Snehal. Snehal, it's a very large question, but the first about the timeline with the IP, I'm comfortable with it. Okay. See, there are the entire timeline is divided into 3 zones. Before you initiate, there are 90 days given to the promoter, then the 90 days to the IP, and 30 days to the NCLT. We don't have 120 days to the IP. IP has to work within 90 days after the initiation. Before the initiation takes place, the promoter, after he takes a resolution to get into this, he is supposed to finish within 90 days. If he doesn't do in 90 days, again, he has to go for a internal board resolution to create that. Now, as our esteemed panel, Mr. Pandey and Ashit said, it makes a lot of sense, which is also, I fully agree there, that you prepare everything before you initiate. It's like a consulting. The IP will do a role of either IP or his own promoter's own chartered accountant or somebody. He has to do a lot of consulting role to keep everything ready. And first of all, of course, I'm very happy to know that SBI is sensitizing their branches, but the promoters themselves will have to be sensitized. And actually, we as an IP decode, we are addressing a number of MSME associations to convince an MSME, because this is a CD driven process. This is not a COC or a bank or a creditor driven process. So first of all, promoter has to come up to agree to this kind of a pre-pack solutions. So that those 90 days or even before that, if all this process is done, then you are almost ready with the entire base resolution plan, and the whole process can be very smooth. And NCLT can be actually given more time. As Mr. Pandey rightly said, you can finish this within a 60 days instead of a 90 days, and you can submit the plan on a 60th or 61st day. We will not address right now what will happen in the preferential, fraudulent kind of. In the normal thing, if the promoter who is affected by the pandemic situation, that's where the ordinance purpose is. The preamble says that if he's genuinely affected by the financial distress due to the pandemic situation, he comes up, he gives this resolution plan, he keeps all this, he comes clean with his books, He talks about a forensic audit, he gets his valuation done, everything ready, and then the valuers may be formally appointed at the time of initiation, and the evaluation report can be submitted in 15-20 days time because it is already ready. So that's my thought on the timeline, because this is, since you have to all remember that since it is a CD driven, you have to have a before the initiation, the entire thing ready. It's a pre-pack. That's what the word is, pre-pack. It's something to be packed well in advance, to given a package ready to the COC and to be discussed with the COC. Now, see, the COC is a very large word for an MSME. MSME is not dealing with a 20 COCs. In our videocon, we had 24 banks. Now, this is a single bank driven. Most of the MSME will be doing with only a one single bank, or at the most two banks. Beyond that, or at the most, you could be having a SIDB associated with, because there is an MSME. But other than that, I think there is no fear about tackling with a very large number of banks and getting into an indecisive process. I think with a one bank, that also at a branch level, as Mr. Pandey will agree, that this will now happen at a branch level. It won't come to the head office level. And the branch people will be given the same branch manager will sanction the loan, who is monitoring the proposal. He will be in a position to sit down with the promoter along with the IP or a consultant to work out that how do we go about it and how do we sort it out. Now you ask the question about the BES resolution plan. How do you work out? See, the promoter will have to work out a sustainable debt. The way in which we are doing a large companies. Similarly, he has to work out an MSME. Suppose MSME is taken out a 50 crore loan. He has to work out that now onwards, let us say hospitality sector or a travel sector and all, what is going to be his sustainable debt? Is his business is going to take care of only 30 crore debt and not 50 crore? Then he gives a BES resolution plan entirely based on that sustainable debt amount. And that is supposed to be negotiated and accepted by the lender, that this is how the sustainable debt has been worked out. So entire BES resolution plan will work on his future projections, his interest cover ratio, his various financial ratios. As a matter of fact, we have already prepared a model based on this. So you create a sustainable debt, and that you are supposed to, so you are not convincing the banker with many other effects of the BES resolution plan. Oh, okay, you might even say that my business will do well if I bring in a partner in the company. And so he talks about a partner or an equity holder or a new person, or he might say that I'm very much able to create a 50 crore debt, sustainable debt, but I would like to have a 3 years moratorium before I start servicing this 50 crore debt. So then he will work out on that. So it is completely a finance, corporate finance game where the BES resolution plan will be developed. The next question, of course, you asked, I'm trying to all summarize briefly as much as possible. You talked about the tick size and the alternative resolution plans. If you do all this in first 90 days, and if your single banker or two bankers are convinced, probably you should hope that you will not have a situation for going for a second resolution plan at all. So-called Swiss challenge method will not come at all. This comes in a very, very different circumstances that you went all alone, you never had any dialogue with your lender, and you just submitted a plan. Lender says nothing doing, I don't agree. So you will have various kinds of promoters, but I think the fundamental you have to look at the preamble of the ordinance, that it is supposed to be looking at the stress of a promoter, and promoter is taking this advantage of the act. So instead of he struggling to answer to the SURFACE notices and DRT notices, it's best that he takes care of this in a proper way, in a very candid way. Then in that case, a resolution plan invitation doesn't, that situation doesn't arise. But suppose if it arises, in case that new resolution plan has to be invited, suppose one banker doesn't agree, or the situations have changed, or let us say the commercial situations has become so rosy that you have to invite.
Dushan, here what happens is, if there is a haircut in the operational creditor, then this Swiss challenge will come into play. Because there should not be a haircut, what I understand from the thing.
So it's a good question because while you are doing that first 90 days before initiation, you have to even drop in operational creditors in your discussion. It's very important. You are taking the all stakeholders meeting and keeping it ready of as a resolution plan so that you don't even have an objection from the operational creditors kind of taking a haircut. I think the purpose behind not giving haircut to operational creditors is not to create another MSME getting into a distress. The idea is that let MSME to MSME, see, MSME supplier will be MSME, MSME customer will be MSME. So you can't have a chain sequence that just to say one MSME, you are creating distress for another. So ideally, you should give full payment to the operational creditors because they are your lifeline. They are supplying raw material to you. And the financial creditors have taken a stake on they have taken security of assets, plant, machinery, so they are well secured. So they will take the haircuts. I think the haircut, even in our CIRP, the haircut was always to the financial creditors. And of course, in that case, the operational creditors are completely wiped out. But if you do that in MSME, I think it will create another issue. So that is where you will invite, in case if you have to invite a resolution plan, you are asking question about the tick size and kind of a thing. I think this is completely COC driven mechanism. You can decide your own tick size. You can decide which plan is significantly better than the other, and you can take a call accordingly.
Okay, okay.
Thank you.
Ashit, in those same point on base plan, your do's and don'ts in preparing the base plan by the MSME promoter, basically, what he should take care in preparing the plan.
Yeah, I think the preparation of the base plan would, in my view, be slightly different from a normal resolution plan which we have in a CRP process. And the main reason being because here the promoter itself is providing, for a plan to restructure the operations. I think it would restructure the company and the debt. So it would focus more on actually restructuring of the capital structure and the debt rather than on operations, which you find a lot more. Operational restructuring is a lot more in a CIRP. I think you would not have a lot of operational restructuring, but more capital and restructuring and debt resizing. As Mr. Dave has mentioned, you have to take into consideration operational creditors' views, especially because if any of those debts are impaired, then you are going to face a Swiss challenge, which is not the case in a CRP process, and which is also not the case when you invite new plans under the pre-pack process. Because under the pre-pack process also, when a new plan is invited, the new plan does not have to make sure that the operational creditor debt is not impaired. The new plan can provide for impairing of the operational creditor debt as long as they are getting paid in priority to the financial creditors and as long as they're getting at least the liquidation value. So when the promoter is preparing a plan, he has to make sure that the OCs can't be. So there is a little bit of a dichotomy, in my view, in the way the ordinance is, but that's important from the perspective of the promoter. I think another key factor probably will be that creditors will want the promoters to infuse some amount of equity into the company, or they will want to make sure that if there is any unviable asset in the company, you sell that asset and come up with a plan on how, the process and the timelines within which you will sell the asset. So promoter contribution in some form, either through sale of assets or through bringing in new equity, will, I think, become an important feature of all of these resolution plans. And I think so. These I would say are some of the key aspects that you should take care of when you are putting together a base resolution plan. Of course, you have to still comply with the code, balance the interests of all stakeholders. All of that has to be done as per the IBC.
Yes. Sanjeev sir, from Ashit, what he spoke on the base resolution plan. My question was like a little bit differing in that how do you see getting the RAs, like what has been where there is a haircut or a impairment basically to the other creditors, which is being suggested in the base resolution plan, then the Swiss challenge and the invitation to the RAs will be done. So here, when you are not marketing, you are just publishing on the CD's website, you are just publishing on the regulator website. how do you see the RAs coming in CRP when a lot of marketing is also done to get the RAs, and the MSME which has gone into CRP has gone into liquidation because none of the RAs have come forward in that thing. Now, when you look into this thing, how do you think the RA will come? And in that given scenario, without circulation in paper, RA not coming in, what do you think that how this prepack will shape into in further things?
So my sense is that when you are preparing the plan, that is the fundamental of this pre-pack. How best you can prepare a base plan, that becomes the benchmark for RAs also, and go with the understanding that 90% of the time we will not get a RA. So if you are entering pre-pack, so go with that understanding. I may not get a RA at all. So your base plan should be such that it can be approved. So that is my, and second thing different here from CIRP, as Ashish Bhai has also slightly hinted. In CIRP, there are no benchmarks for resolution plan. Anything can be a resolution plan. So we have seen resolution plan like 95% haircut also, they have been approved. There are plans like Aircel and all, like only 3% or 4% recovery is there. But here, since we are dealing with the promoters, nobody will accept those kind of plans here. So here you have to start with certain benchmarks for resolution plan. So we are also proposing in the bank that we have certain level of fixed asset coverage ratio, some interest coverage ratio, some minimum level of cash flow, security, what is the post plan coverage. So all those things, interest rate, what can be the acceptable interest rate for the bank, minimum interest rate after the approval. We cannot offer a 0% interest rate. So those kind of things have to be there. So and have to be provided upfront to the branches so that on that benchmark, they test this plan, base plan, or rather they build this plan on the reverse model, reverse engineering. Yeah, they put up those parameters in place and then start working on reverse and reach certain level of sales and profits, and then test it with the reality whether the unit can achieve that. So as Mr. Dushyant were telling, you have to work out a sustainable debt. So that is exactly I'm talking about. So this sustainable debt will be that which will achieve those kind of ratios which are already provided. So that is not there in CRP, but here we have to do that. As regard your question of inviting RAs, what we have seen is that in these kind of companies, small companies, local level industries or the businessmen are interested. Like you have a unit in a Ludhiana industrial area. So nobody from Mumbai or Delhi will go there and acquire that unit. Somebody from neighborhood, like in that same industrial area or another industrial area, may be interested in acquiring, maybe because of the land or the machinery or whatever. So that is, so what we can do is that you market these locally. You don't have to go across the world. You have to do local marketing. Then you can get some RS. So you don't have to spend too much on the marketing. And in any case, even under CRP also, despite all that investment banking and marketing, I don't think in many cases there were more than 10 RAs came. Even in large cases, there were few. So here also, we should expect that 1 or 2 will come, and they will be most certainly from the neighborhood only.
So, sir, what I understand from you and Dushyant Bhai's talk is sustainable debt and the ratios and the checklist. So we are going back to our old CDR days where you have a formula which was being given based on which a restructuring was being done. So that formula, the CD works on that formula, keeps everything ready, put the base plan as per the formula of the banks that he is associated with, and then puts the pre-pack. So things. So it moves in a smooth direction. So more or less, what pre-pack means is the combination of the old restructuring model with the new CRP model. Combination of two comes into the pre-pack thing, and that goes.
One kind of plan. My sense is that some plans will be something like OTS kind of proposal. The borrower will come in, simple, give, sir, I will pay you this. You settle, get it approved by NCLT. So it is binding on everybody. He can get some, and then we are out. So that will be one kind of plans. Then most of the plans will be the restructuring type. Some may come in as merger and acquisition. Somebody comes in, he is interested in enhancing some backward forward integration. So few will be like that, but not other than these three. I think the scheme is giving some 9-10 kind of plans, but I don't see more than 3 types. That is my sense.
Okay. Sudha madam, you being a IP and a valuer and on the board of various companies, the question to you is on the valuation, basically. In CRP, we had to appoint two valuers. Okay, if the value differs, we have to appoint third valuer. Here, on the third day, we have to appoint two valuers. How do you see the valuations playing the role in this pre-pack?
Yeah, so under CIRP, if you see, the resolution professional used to call for the values, and then if the valuer were differently, too much different from each other, he was equipped that he could appoint another registered valuer who shall submit an estimate of the value, and then he could take the average of it. However, in contrast to this, under PIRP, this provision, this privilege that was given to RP that he could call for the third value has been taken away. So under PIRP, the average of the value determined by the two registered valuer is required to be considered to be fair value or registered the liquidation value, as the case may be. However, since the PIRP is a self-started process by CD, I think some of the challenges that we were facing while doing valuation under CIRP, like limited access to documents, no staff to speak with, challenges in case of physical verification, they should not be there. That's what we are looking at, that in case the CD doesn't cooperate, he knows that he can, the whole of the process of PIRP can be stalled by the COC.
Okay. Point blank question on 29A applicability, which has been put in this pre-pack. As we all know, most of the MSME is basically MSME is considered as an unorganized sector. Financial discipline in MSME to a great extent is not there. That we understand very much. In that scenario, a declaration given by the promoter to at the initial with the application that he is 29A compliant. How far out of the avoidance transaction, that is PUF, what we used to say, preferential, undervalued, fraudulent, and exorbitant, how far the preferential transaction will play a role? Fraudulent, undervalued, exorbitant is apart. A preferential transaction in view, Ashit, in your view, how far that will play a role? Any views? This question, each of the panelists, I would request to have your views on this, so that we come to a conclusion, because what has been discussed in various forums and what has been understood by that this 29A may be a non-starter for pre-pack. So is it so, or how do you look into this 29A into this model? Yes, Ashit.
Yeah, thanks, Sneha. So I think as far as 29A is concerned, as far for MSMEs, there were a couple of carve-outs which were made under the IBC. So the two carve-outs which were made is that where the account has been an NPA for at least 12 months, then you can't be a resolution applicant. That carve-out is there for MSMEs already. And the second carve-out is on the invocation of guarantees and non-payment. As far as the account being, as far as the resolution applicant being a promoter of a company where there has been a preferential transaction concerned, that is not a carve-out for MSMEs. And therefore, if there is a preferential transaction which has taken place in the corporate debtor, and the corporate debtor makes a declaration, because he has to make a declaration that there is no preferential transaction. So if the corporate debtor actually does make a declaration that there is a preferential transaction, I think there could be some challenges in interpreting whether the corporate debtor is therefore compliant with 29A as far as MSMEs is concerned. So that's a point which will have to be looked at, because the law clearly says that either you make a declaration that there is no avoidance transaction, or in case there are avoidance transactions, then you declare those avoidance transactions. So if you are declaring those avoidance transactions, that by itself should not make you ineligible under section 29A. But I think the law is not clear on that point, and that is something which we will have to see as we go ahead, and maybe some clarification, if any on that point can be made out. It would help clearly to make this more successful amongst the MSMEs.
Okay. Sanjeev sir, your views on it?
Yeah, this is one of the, I think, hindrance in this PPRP. But I feel that the IBC is also for formalization of business. So the MSMEs have for a long time worked in the gray part of the business area. They have to come in the open, work in the formalized environment. And somebody who is really, who want to intend to go for this, maybe he wait for 2 years so that he get out of that timeline, 2 years look back period for this. But there will be problem because most of these MSMEs, the corporate account and the personal account have a lot of intermingling. So most of the personal expenses, family expenses are routed through the corporate account. So that is a problem. We understand that will come. At the same time, as I'll agree with Ashish Bhai, that if some clarity comes and upfront the promoter declares that these are the transactions used by me for my personal expenses, maybe in the nature of preferential, but I will be able to bring that kind of money to the account so that I do not, I can fulfill the damage. So I think then that kind of forbearance should be possible. So,
Okay, Dushyant bhai, your views?
Okay. Yeah. Okay. I can. I was not able
Yes.
to unmute. So
Yes.
yeah, I think I tend to agree with both Ashit and Mr. Pandey, because incidentally, when I was looking at the various forms to be provided, it says that you declare that at the time of submitting the resolution plan approved by the COC, RP simply declares that this was done. It doesn't show anywhere that you can't conclude it if this is the case, a kind of a thing. But as preferential transactions come under a 29A, the only way to come out is a disclosure, and the way to treat it. I think that's the only solution. I think, and maybe since this is a practical issue, as Bishop and so rightly said, that personal expenses and the because promoter is a single promoter driven, maybe an LLP, and directors are two brothers or father son or cousins and uncles and all, so they are all spending even probably most personal expenses to the same account. So this is going to be, so probably if the so let us say an accountant, when during the first 90 days he takes out all the list of the preferential transactions, so they turn out to be simply more innocent personal expenses rather than siphoning of the money. See, there are two things. One is a preferential, you have taken out the money from the system, taken away the bank money and given it to somebody else. That is, a dishonest preferential transaction. You have taken a preferential transaction when you are just taking care of your personal expenses.
So
Then probably this can be taken care of by promoter declaring that I'm going to take care of this. I'll repay this or something like that. That's the only solution.
What about 77A offenses? If you are going, it's like a Abel Mujhe Maar. If you are declaring upfront and telling, then how do you take 77A into picture then? So because there, apart from declaration, in 77A, if it is a wrong declaration, like preferential transaction, to my understanding, most of the MSME will not able to understand only what is meant by preferential transaction. Okay, so in that given scenario, he has given a declaration considering X transaction as preferential, and the RP who takes the support of an expert in forming his opinion within 30 days whether there is more preferential, and if some more preferential transaction comes into play, maybe not a dishonest one, but honestly it is unknowingly he had done that transaction in the company, and he falls into the trap of 77A, where there is a criminalization, where there is an imprisonment that can go because of the wrongful declaration. So this all things, if embedded together, basically the idea to share on 29A, take your views, was to understand the gravity that it can go into probably, and the as we were discussing in other forums, that this may be a non-starter unless, as Ashit said, that declaration being given and guidance coming out on that, if the declaration is given, then probably that may be excluded from the things. And as Sanjeevji additionally suggested that if declaration is given and he's ready to bring that money back also, then it should be not be considered on for that purpose. So the idea on this 29A being put in pre-pack, as such, when the IBC came, what we all know, this 29A, as it came in the mid of implementation of IBC, because it was being misused, and this 29A came. Then it got diluted, whereby you got a discount on MSME promoters on certain sections. Now, when you are talking of pre-pack, and again you are putting 29A with the dilutions of two sections, subsections which MSME promoter has, but not looking into the puff, it seems to be a non-starter for pre-pack unless a clear guidance comes. So this is what I wanted from the panel to have a clarity on. We have another 10-15 minutes. I take one question and we'll take then thereafter Q&A on the things, so that the certain questions what I have been seeing in the chat box can be taken into consideration. So after the puff transaction, base resolution plan, which is the key heart of the things, RA point that we discussed, where how to bring RA. Now, one typical question, which is again open to all the panelists, which will be that is there is a pre-process that is to be done, and then after admission, the RP under the supervision of COC, RP has to supervise and report to COC, and he has to perform his duties. Is the person who does the first half advisory to the CD, RP, can be the RP in the second half? Won't there be a conflict between the two? Won't there be a COC, as we have been continuously seeing in CRP, COC changing the RPs just because either not in their panel, appointed by OC or something or the other things? So here, if the change of RP comes into play, whether the things will go smoothly, whether the conflict will come or not. I think again I would start with Ashit being the legal part. From there we take it from to the operational part. Yes, Ashit.
Thanks, Neil. I think the chance of a conflict, in my view, is low, and the reason I say that is because the RP who is appointed, even prior to the CIRP, prior to the pre-pack process commencing in the informal stage, is also somebody who is ultimately approved by the creditors, because you still have 66% of the creditors approving that particular person will be the RP for the pre-pack process. And that person who gets appointed is then, helping with the informal stage, so as to say. Plus, as far as his fees, expenses are concerned, those all have to get paid while they get paid by the corporate debtor. That does not, I think, automatically mean that he is biased towards the corporate debtor, because his appointment is being confirmed by 66% of the financial creditors. So if the financial creditors don't approve a particular person, he can't be appointed as the RP even in the informal stage. So I think the chances of a conflict are fewer, I think. Yeah.
Yes. Dushanta, your views?
Yeah, I agree there, because IP, he's covered by the 54A rules before even he initiated. So I think he's also governed by the same IBC rules regulations. I don't see any conflict of interest, because COC would have already approved the appointment of RP. I think if at all the change happens, it might happen purely because of the administrative reasons, rather than COC not liking the face of the RP.
Sanjeevji, your comment on not liking the face of the RP.
This will be the ideal situation where the IP is identified by the financial creditor, And I think my sense is that there will not be more than 1 or 2 FCs here in these cases, no? Because for a 250 crore sales for MSMEs, highest, the limits will be somewhere around, maximum limit will be 50 to 60 crores, not more than that. I don't see too many banks coming in for 60 crore kind of a limit today. So most of the time it will be either single bank or maybe at most 2 banks. And there also one bank will be somewhere more than 66% because he must be original banker, second bank has come in late. Even if it is 50-50, it will be good that they sit together or decide upfront whom to appoint the IP so that they don't have a tussle later. And ideally, they should suggest the name of the IP at the initial stage so that he works with the CD all through the process, including forensic audit, including valuation. Valuation should start at the initial stage. It should not wait for the admission. All these things are possible. And then only I think we can conclude and reach a good conclusion of a good base plan. So I don't see any conflict.
Yes.
One more thing we have to understand is that these are small cases, but they will be voluminous. Number of cases will be very high. Unlike CRP, where one branch may be having 1 case or 2 cases or 5 cases, here even a small my SME branch may be having 50-100 cases. So RP should be conscious that if we do some hanky-panky in 1 case, he'll be totally out of business with that branch. So
Sir,
he
why,
has to maintain
sir,
his
why
integrity.
always RP do hanky-panky business, sir? RPs are very humble, sir. They always follow deadlines.
See, ultimately, everything will come out, whatever he do, whether he collaborates or colludes with the promoter. So next plan, he will be out. He will not get further business. So that is the pitfall for.
So, sir, how do you see limiting the assignments? Like in CRP, your SBI limits it to 3. After that, you give 0 score to the RPs. What we understand,
I
all the
think
RPs. So
so
in
maybe
pre-packs, how many assignments you will give after 0 score? Just a lighter note, sir.
we believe in like diversity of work. Everybody should get work. Everybody should be able to show their talent. So my sense is that I think 4 or 5 assignment each IP at a particular time, because here the assignment completion time is also less. In 1 year, if you go exactly by the law, so he can do 3 assignments.
Right.
Like 120 days into 3. So I think 4 or 5 should be okay.
Okay, great, sir. Now, with this, basically, we actually close our panel discussion and I summarize what we discussed, and then we take the questions in the chat box, because the chat box is full with lot of questions, which shows lot of negativity on this pre-packs, which I feel is something not needed for, because the requirement of pre-pack, what I understand, is the change in mindset of the CD, the change in mindset of the COC to look into this process. Because if the CD who has done the fraudulent transaction, it is not meant for them. The as Dushan Bhai rightly said that CD who has basically unknowingly done something and because of which he is getting into trouble, okay, that is what needs to be looked into. But this transaction, as Sanjeev sir also said in his talk, that it is at the time of when account comes into SME 1 or SME 2, the default occurs. It is not even NPE. At that time, when you foresee that future payments are in trouble, you go to the banker and say that I want to restructure. And he says that there is an issue in restructuring because of certain policies. But if you come under pre-pack, probably we will be able to sail through. And then you discuss with him the base plan that you want to prepare, which he says, okay, this is what our authorities may accept it, because it is going to be approved by a adjudicating authority at the finality. And in principally, we will be okay with it. So this pre-pack is meant for them. It is not meant for all. This is not a process, what I understand, that it is meant for all the MSME to come out of the things. It is meant for the MSME who have got a hit due to X reason, who have taken a call and which has backfired at their end, and they have understood their mistake and want to revise it. And they want to go to their lenders who are their financial partners basically and tell them that I have done this mistake, allow me to come back through my pre-pack proposition. This pre-pack proposition is what I understand in these things. from the understanding of the panel discussion that we have, what I have been able to conclude is that pre-pack requires a mindset change. Pre-pack requires it's a whole set of opportunities for professionals to advise MSME to come out of this vicious circle. But it cannot be looked into that the COC will not accept. If the proposal is not acceptable only, then it should not come under pre-pack. It cannot come under anything then. So there should be a win-win situation. As Sanjeev sir says that 5% only payment they have received, 95% haircut they have accepted in CRP. But it was a forceful acceptance because the company would go into liquidation and that 5% may not come. But that may not be the scenario in pre-pack, because from pre-pack to CRP, from pre-pack to liquidation, all the things will be in the hands of the COC. Even the fraudulent management or mismanagement during this period of pre-pack, the COC has a power to vest the management with the RP. So all types of checks are kept into the pre-pack. So a right unit, a right corporate, MSME corporate should actually evaluate their own proposal first, whether they are fit for pre-packs, and then go into pre-pack. Otherwise, it may be a suicidal for them on these lines. Specific questions that we have in the chat box, which any of the panelists would like to take. I will take 2 questions before we take it for the closure. One question is insolvency, whether regular or pre-pack is a theory for the benefit of data. It is not a recovery method like DRT. So yes, I think more than question in the chat box, they have answered. Someone has questioned and someone has answered many things.
Yeah, let me take this. So
yes, sir.
This is it is something different from restructuring, deeper than restructuring.
Yes.
And different from recovery. Recovery in the sense that it can be, the base plan can be a one-time settlement plan. So of course, can be a recovery. But at the same time, it comes with the force of the bank to take the company to CRPC. One thing one must appreciate here, once you get into pre-pack, then the entire momentum is in the hands of COC. So COC can terminate the pre-pack anytime, take you to CRP. So when we see that many cases, the promoters are just trying to hold back the admission. So this can be indirect route for the banks to take the promoter to NCLT. Yeah, one should be very clear-minded when you're entering this, that entire initiative and momentum is with COC. So one should not play games there. They should go with a clean heart and clean hands. Then only, first of all, banks will agree to PPRP. Unless the debtor is clean, nobody will agree to this. Some may agree indirectly to take you to CRP because we have the handle now. Once you are admitted, just by a simple resolution, the PPRP can be converted to a CIRP. So, but coming back to that this is the recovery part. That one can be a OTS proposal, other one can be a restructuring. What we have seen that banks are not very comfortable in taking haircuts out of court. See, I have not seen many restructuring proposals. What is done is some of the loans are rephased, rescheduled, but the debt stays. And that is not a resolution actually. Unless the debt is removed, debt burden has to be removed to make a company sustainable. That is called sustainable debt. But here what is happening? We convert the irregularity into a WCTL or a FITL. Ultimately, it remains on the books. And then again, the company comes back for a restructuring 2 years later. So what opportunity available here is that bank will be comfortable in taking a haircut so that some of the burden is entirely removed. But at the same time, the promoter also has to take a haircut by way of equity downsizing or bring in some money, and then it can be tested in the market for the value. So these are the positives. So I don't think some cynicism is required here. We should be positive about this.
Right. So thank you, Sanjeev ji, on this point. On the questions, what I would suggest that we will not be able to take the questions as the time is running out. And what I would suggest our team basically can we take the questions at our end and then prepare with the help of our panelists, prepare the answers for that and share with all the registered participants so that we can give the benefit of that to all. And we can do, I think, probably right? Okay. So we will be able to do that probably. We'll be taking the questions that are put in the chat box. Will be shared with our panelists and their views on that. And then we will try and share with all the participants who have attended this session. And with this, I would like to conclude this panel discussion and hand it over to the host.
Thank you. Thank you for that wonderful and knowledgeable session. As we come to the conclusion, may I request Mr. Juzer Khorakiwala, Vice President, IMC Chamber of Commerce and Industry, to present the vote of thanks. Over to you, Mr. Khorakiwala.
Thank you, Selvi, and good evening to all of you. It's been a long 2-hour session and a very important session, I must say, because I myself have learned a lot from which I didn't know anything about this pre-packed issue. And I'm sure our over 200 participants who were logged in today would have been delighted to hear from such eminent panelists this evening. MSMEs do form a very important of our, and unless and until a proper backbone is given to the MSME, we will never have, in the long run, very large corporations emerging out of these MSMEs. So I think the vision that is now coming into force would go a long way in building the backbone of our country. We have had very eminent panelists. First of all, I must thank Mr. Shukla for delivering his opening remarks, and Mr. Kamdar, Mrs. Snehal Kamdar, for steering this entire panel discussion so brilliantly this evening. We have an excellent panelist, Mr. Ashish Shah from Sagar Associates, Mr. Dushyant Dave, of course, Mr. Sanjeev Pandey and Mr. Sudha Bhushan for their beautiful insights into the whole this afternoon. As they said, it has been a impactful reform, as Mrs. Sudha Bhushan has mentioned, and a game changer, as Mr. Dushan mentioned. And I would like to end by saying that the best pre-packed insolvency reform was given by Shakespeare many years ago when he said, "Neither the lender nor the borrower be." So on this note, I'd like to thank again everybody and IMC and IP for putting this event together. Thank you and good evening.
Thank you, sir. Thank you. Okay.